Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On May 14th, 2025, the defense filed a second motion to seal defendant's proposed jury instructions. It states here, comes now Brian C. Kohberger by and through his attorneys of record, and hereby moves the court for an order to seal the defendant's second notice of filing proposed jury instructions. Second page states the motion is made pursuant to ICAR 32I and IC section 74124(1)B and C because they are either previously already sealed or are redacted. Dated the 14th of May 2025, signed by defense counsel Ann C. Taylor. Now, multiple questions arise here on my part, and I give my opinions pursuant to the First Amendment to the U.S. Constitution, as I always do. There's no reason given here why there is a purpose for a second set of jury instructions from the defense. Is this supplementing the first set of jury instructions? Is it amending them entirely? Is it taking away a prior jury instruction, adding another one? The public remains in the dark because this is under seal. Secondly, although the statement here that the good cause for sealing these second proposed jury instructions because they are either previously already sealed or are redacted, they're not redacted. They're all previously sealed. Every single jury instruction proposed, submitted by both sides, were submitted under seal, and Judge Stephen J. Hippler has signed all orders, including this motion, to have jury instructions under seal, which is quite perplexing because many jury instructions in civil and criminal cases are standard. They're the type of jury instructions that we've addressed in prior episodes of our content here on the podcast or on our sister YouTube channel, pointing out that the Idaho Supreme Court has approved standard jury instructions, including what, for example, is the difference between the trier of fact, who is the jury, and the trier of the law, and giving what the law says on that. I would imagine that a jury instruction like that is utilized in a number of criminal cases, and maybe in this case, it's not case specific. So why is every single jury instruction completely under seal, at least not redacted? And then also, the legal authority here does not cite what I think is a very important legal authority, and neither have any of the motions to seal any of the proposed jury instructions in this case. I am referring to Judge Stephen J. Hippler's October 9th, 2024, redacted order governing further criminal proceedings and notice of trial setting. I've called this the pretrial and trial order, page number 3. You see under the section trial materials a number of items that were required to be sealed and that were addressed in this order, such as the proposed jury questionnaires were to be filed under seal by both sides, exhibit list filed under seal, guilt phase lay witnesses to be filed under seal. Nothing absolutely, if you look at the second bullet point, where the proposed jury instructions shall be filed by April 14th, 2025. Objections and or stipulations to the proposed jury instructions are due by April 21st, 2025. So not only is the fact that Judge Hippler never required the parties to ever file any of their jury instructions under seal per this trial and pretrial order, this pretrial and trial order is not cited to here, and now the public is left with the question, why is a second set of jury instructions being submitted a month after the deadline to submit the proposed jury instructions to the court? Well, we're not going to know, at least not anytime soon, because on the 14th of May, Judge Hippler entered the order sealing defendants' proposed jury instructions, accepting the legal authority given, no mention of the court's own order, no mention as to why it is that jury instructions are completely sealed in this case. This will now conclude this episode of the Indie Zone podcast. Thank you for joining us today.